The Islamic religion is complete guidance comprising three main important elements: Aqidah, Sharia, and Akhlaq. Thus, it governs all aspects of human relationships and dealings, whether among the people themselves, the people and the universe, or between people and God. The concept of the relationship between Islam and the state has long been the subject of discourse among both classical jurists and modern scholars. Constitutional law is part of the formation and constituents of the state and its legal system.
What is the definition of constitutional law? To begin, there is no uniform definition of constitution given by constitutional lawyers, either written or unwritten. The former refers to constitutional rules which are compiled in a single document, whereas the latter, such rules are scattered and to be found in many sources, such as the Constitution of the United Kingdom. In a sense, it may be defined as the document in which are set out the rules governing the composition, powers, and methods of operation of the main institution of government, and the general principles applicable to their relations to the citizens. Its drafting may take into account considerations of circumstances and the special problems faced by the state. Constitutional law is a skeleton, a framework which has to be filled out with detailed rules and practices. A state requires constitution and constitutional principles in order to show the direction and the way the state should operate. Essentially, definition of constitutional law is universal, and the Muslim scholars seem to have used the same definition in terms of its scope and coverage. What is different in the context of Islam is its basic contents and philosophy.
Do you know that after independence, Islamic evidence law has begun to gain attention in line with the development of the institution of the Sharia Court? The Sharia Court evidence enactment has been approved and implemented in all states. Currently, the administration of Islamic law in Malaysia, including Sharia Court evidence enactment, is in the phase of consolidation and improvement. The National Islamic Religious Affairs Council, under the Secretariat of the Malaysian Islamic Development Department, has initiated initiative toward the standardization of Islamic administrative law. As a result, now the restructuring of Islamic religious affairs in the state has been separated between the powers of the Islamic Religious Council, the Mufti, and the Sharia Court.
The federal government have drafted 4 new Sharia laws, including a bill on control and restriction on the development of non-Muslim religion. Ahmad Marzuq Sha'ari, who is Deputy Minister in the Prime Minister's Department of Religious Affairs, said a Waqf Bill, Mufti Bill and Sharia Court Bill were the other new laws being planned. The government has drafted a plan to strengthen Sharia laws, especially in the federal territories, over a period of 5 years from 2020 to 2025. In this empowerment plan, the government has proposed to enact 11 key Sharia laws, which include the enactment of new laws and amendment to existing laws. The proposed amendment bill gave rise to an opposition outcry, with politicians and civil society groups accusing the federal government of seeking to allow the implementation of hudud as part of the Islamic Penal Code. Islamic laws and the Islamic Penal Code come under the jurisdiction of state government, but are handled by the federal government in the federal territories of Kuala Lumpur, Putrajaya and Labuan.
One of the bodies established under the legislation is the Muslim Religious Council, which known as Majlis Agama Islam. The members of the council are from the top level of state public servants, including the state secretary, state legal advisor, state financial officer, state chief police officer, mufti, and those who are learning Islamic law. The council is the main Islamic body since it aids and advises the rulers on the matters of Islam, and also has the responsibility to promote economic and social development of Muslim communities.
There are references made on the existence of learned persons in Islamic law as officers in state administration during the Melaka Malay Sultanate in Sejarah Melayu. The learned person was called Qadi at that time. Then the Mufti, as a qualified person and having the duty to give opinions on some issues regarding the Islamic law, is very important as an aid to the Sultan. There is a proposal for the establishment of the position of the Grand Mufti in order to overcome this problem and requires an amendment to the Federal Constitution. Furthermore, the Mufti is closely related to the power of the Sultan as the head of the Islamic religion. However, the possibility of such an amendment is small. Rulers have shown their readiness to be firm in situations related to their position and power.
Jurisdiction of the Sharia Court in Malaysia. As we know, the Malaysian Constitution permits states to establish court with jurisdiction over Muslim, and recently has given them exclusive power to adjudicate matters of their state's Islamic law. State Sharia Court can adjudicate cases arising under Islamic law and personal and family law of person professing the religion of Islam, including the Islamic law relating to betrothal, marriage, divorce, dower, maintenance, adoption, legitimacy, and guardianship. State governments have the authority to establish their own body of Islamic law to regulate inheritance.
Article 74 of Federal Constitution outlined the division of legislative powers into two separate branches, federal and state. This provision empowered each state to enact and regulate Islamic affairs by their own. The power were given to the respective state legislatures to enact and implement laws in regard to Muslim affairs without the interference of federal government. For instance, in the establishment of Muslim Religious Council and Sharia courts. This matter clearly illustrated in the case of Muhammad bin Daud, which ruled that the parliament has no powers to enact any laws related to Islamic matters. However, the jurisdiction in the scope of Islamic finance shall fall under federal government authorities, and all cases related to it shall be heard in the civil court instead of Sharia courts.
Hi, so now let's move on into Wakaf in Malaysia. The administration of Wakaf, which means Islamic religious endowments, is conducted by the state's Islamic Religious Council, which known as Majlis Agama Islam, and for your information, the disputes regarding Wakaf are resolved in Sharia courts. The state governments can establish the laws and regulate Wakaf and other things like trusts, charities and charitable institutions operating completely within the state. Likewise, state governments can establish their own regulations governing zakat, which means obligatory charitable giving, and similar Islamic methods of raising revenue to support Islam and the Muslim community. Next, we will talk about Sharia lawyers in Islamic administration. The administration of Islamic law allows persons who are admitted as Sharia attorneys in one state to be admitted as Sharia lawyers in other states after showing proof of their admission. Thus, there is no need for a person to get through a long process of applying for a Sharia lawyer if they intend to practice in those states, but it's also not fully applied in some states.
Next, who is the head of Islam? Actually, there is no head of Muslim for the federation, but the King Yang di-Pertuan Agong is the head of Islam in every state except Malacca, Penang, Sabah and Sarawak. These states have no Malay rulers of their own. The remaining 9 states of Malaysia have their own ruler. Sultan is the head of Islam in that state. Based on Federal Constitution Article 3 Clause 2, the king is authorized to represent each of the rulers as the head of religion in their state. Though the state government has the power to enact laws for Muslims, it only relates to and governs personal laws and family matters. It shows that if the state government can enact laws even in criminal matters, their jurisdiction are still limited. To sum up this documentary video, the fundamental instrument that established Malaysia's federation in the form of the Federal Constitution explicitly states that Islam has a position in public life, including in areas of justice administration and Muslim affairs. The Constitution enables for Islamic law to be codified and Sharia courts to be established. Although not all states with a majority Muslim population such as Malaysia that place Islamic law administration in the mainstream. The states must nevertheless deal with the subject of Islam and human rights. Nonetheless, as in Malaysia, each country's legislative and judiciary should be granted the freedom to establish our own law.